Less stress, more time, more money. Welcome to the Cash Flow Contractor. Interview.
Martin, do you remember when we used to make sounds on Zencastr for different segments?
Sound? Oh yeah, we hit your little buttons. That's the one I was thinking of. I'm
I
glad
haven't
we
done
don't do
that in
that
like
anymore.
9 months at least. It's been a while.
I'm sure everybody's missing it.
Yeah, I'm sure everyone's missing it. Martin, what if there was a sound for every time you could potentially get sued for something as a contractor? Like it just went off like that. How
Well,
do you
that
think that
reminds
would
me of
go
a
off?
joke by Mitch Hedberg. He said, "If fish could scream, the ocean would be loud." So if there were a sound for every time you could get sued, it would be loud.
It would be loud. Well, hey, we've got a special guest who knows all about the issues that subcontractors run into and how many times that sound would go off. Karalynn, thanks for joining us today.
Thank you so much for having me. I'm
Yeah,
excited to talk about all the dangerous things.
all the dangerous things.
I hate to be Debbie Downer all the time, man.
No, it's all right. I mean, sometimes we need that person to be able to point or raise the flag and be like, "Hey, you need to fix that. Hey, this is an issue." And I don't. I think contractors think about this, but I don't think they're aware of how big of a deal it is. So
I agree. There's things like when you're a leader and a visionary, there's so many exciting things to do, like the next project, here's our next goal, yay.
yeah,
But then there's a part of being that visionary that has to do the responsible part, which is, okay, where are my liabilities and how can I fix them? So if something does happen, I'm protected as I can possibly be.
yeah. It's an interesting thing because for most contractors, it's not the first thing that comes to mind. I think, especially for subs that are just doing work for GCs.
hmm
I think they think that the legal's built in because the GC has them sign a contract, and I think in their
That's
mind
often
they're
why
like,
we
"Oh, like
need
this
legal.
covers me," you know. But what's the reality there? It's actually probably gonna screw you over in some ways.
Exactly. I mean, I have never seen a more one-sided document as the one
Mm,
between a general contractor and a sub. And I think you're right. I think a lot of subs just think, hey, there can't be anything bad in there. There's a set of rules that protect me, and there's not. There's not a set of rules. It's written in a way you can't understand it on purpose because there's so many bad things in there, right? So the first thing to do is just understand what's in there, right? And
yeah,
then you can evaluate the risk because the way they're written, you can't even understand what's in there, what you're supposed to do, because it's buried in this legalese. I mean, it takes me forever to decipher it. It doesn't have to be that way.
I think
mm,
there are two other reasons they don't do it. And one is they're scared to stand up to the GC. That's not always true. And the other is a perception of cost, like, well, it'll cost me
yeah,
thousands if I start bringing attorneys in here. So I'll just go with it and hope it works out.
Well, and so I see that. I'm so familiar with having these conversations with my contractors. I've come up with a flat fee. So, and you could build it into your bid, right? So 0 to 15 pages on a subcontract is $550. I think it's 15 to 30 is 1,050. Oh, after that, it's hourly. But I will take the contract and I will tell you what it means. And the GC never has to know I'm there. I'm just going to give you the language to modify, to add if you want to.
mm,
But the main thing is that we're clear about what you're supposed to do. Like I'm going to tell you this is what this means. You need to have this insurance, you need to have this daily report, I'm saying pull all that out. And then you as a business person can evaluate the risk. Here's the paid when paid clause. Here's some ideas on how to deal with that. But if you don't know and you're going in blind, almost every time you're going to fail.
yeah.
Every time.
I mean,
Just how bad is it going to be?
I've talked to GCs that they know whether a sub is professional or not, whether they should really keep them around if they look at their contract and actually read it. And they come back and say, "Hey, I want to change this," because
Yeah.
they know I would never sign that document as a sub. Like, I would
Yeah.
not put myself in that situation. So if you're just going to sign it, I might have to double check if I'm going to work with you long term or not. So
Exactly. And I think that's true, right? I think that's true across the board. Everybody's so afraid of pushing back. And that's really how these contracts have gotten so one-sided. For years, the subs have just signed it and never pushed back. And nobody's having the conversation about, no, this is not right. Don't be wrong. There is risk in construction. There's risk in working on credit, but don't push it all downhill. Let's split some of that risk, like the pay when paid clause. The sub does not get paid unless the GC gets paid. I mean, what the hell? I mean, let's split that. There's ways to negotiate that, but putting all the risk of non-payment on the sub who is actually extending credit, paying his guys, paying for material, they are financing the job. There's got to be some give and take here.
Let's run through some of these clauses, because I'm going to be aware of them, but I'm not going to know them as much as you do. So pay one, that's a good one. What are some other clauses that you see in some of these contracts?
Okay, so what are some of the other things that, one of the big ones that I don't think anybody understands is, like, in the first 2 pages of a subcontract, there's going to be something that lists that says, here are the contract documents, right? And it's not just a subcontract. One of them, I've never seen a subcontract that doesn't do this. It incorporates, means it makes you responsible for the contract between the owner and the general, which is the prime contract.
Okay.
You've never seen this contract. You have no idea what it says, and you're just agreeing to the terms of it, right? And it doesn't even say you can get a copy. And so, I mean, how can you expect it to be bound by a contract you've never seen and reviewed? And so, like at Subcontractor Institute, for free, I have some language in there that say, hey, either take this out or at least give me a copy of it, because I can't be held responsible to a document I've never seen. And honestly, what it is, it's lazy lawyering. The lawyer is afraid that they missed something, so they took from that one and put it in the subcontract.
Just to cover, like, hey, let's just cover everything.
Just in case I forgot something, there's a catch-all.
Well, for my clarity, what you're saying is the subcontractor agrees to be responsible for the contract the general contractor signed with the customer?
Correct.
That's what you're saying. Yeah.
Correct. And there's some terms in there. There might be delay damages in there that aren't in the subcontract, or there might be some other things. I've seen it used, which I think this is a stretch, where the sub gets the change order approved by the GC per their contract. Something happens to the GC, they go out of business, the sub files the lien, right? Tries to get paid, and the owner's like, hey, no, you were under my contract, and under my contract, I have to sign the change orders. And since you didn't have me sign it, you can't get paid. And just all these creative ideas that can be come up with. And here's the thing is, like, you guys got to understand, I don't ever see a good project. I just see how these contracts can be used against you if something goes wrong. Right.
Yeah. And you know the people. I mean, that's the problem, is a lot of these guys go off of this handshake, and like, he's a great guy. I know his family, we've been buddies forever. He's a buddy of my buddy. They wouldn't screw me over. But at the end of the day, you do need someone that's going to back away from the relationship, from the emotional side of this. And that's just going to look at the facts. That's going to look at the logic in the contract and say, hey, you're not covered here. This is all the risk that you're taking on. And this means that, yeah, maybe you have a good relationship with your buddy, but what all these people you hired that you have relationships that are on your team? What about their families whenever you go out of business because you signed a bad contract? I mean, the impacts are tremendous in this situation. That's what people don't really think through. So it's really important to go through that. What are some other clauses that you see?
Okay, so another one kind of on that same tune is every subcontract has, a list of defaults and then a termination clause. And so what a default is, just so you know, is anything that you're supposed to do under the contract that you don't do, right? So if you're supposed to do daily reports and you don't, or if you don't have the correct insurance and you don't sign the correct lien waiver and you don't, any of those little things are all defaults. And when somebody sends you an email saying, hey, I didn't get this lien waiver, or hey, I didn't get a daily report, that is a notice of default. So a notice of default doesn't have to come from a lawyer. It can be very informal, like an email. And don't get me wrong, when you're going throughout the project, that's going to happen. That's fine. But what they can hang their hat on is if you don't cure it, if you don't fix it, then you can be terminated, right? And here's a big misconception that's out there, is that when you're terminated, all you're going to lose is the money that they owe you. That is not the truth. If you walk away from a job, you lose the money that they owe you. And if it costs them more to replace your scope than what you agreed to do, you're on the hook for that difference, because you promised to do this work for X dollars and you didn't. And so now they've been damaged and they can come after you for those damages. And actually most of the subcontracts are the damages plus the contractor. The GC has a 15% administrative fee for having to replace
Do it
you
all again.
on top of that. So it's never just, you can't just walk the job and think that you're done.
So, like
Go ahead.
an example of this playing out is, daily reports are required. Busy day, whatever happens, I don't get the daily report in. Does that mean I'm essentially I default and can be terminated right there and then have all these expenses? Is that an example?
You could. They can use that as an excuse, right?
Right.
Generally, when they're going to give you a notice of default like that, so there's two ways to be terminated. You don't cure default, right? But defaults in a contract, like if you're in default, you didn't turn in a daily report. What that could be used for is I don't have to pay you because you're in default under the contract, right? That's when it's more used in the contract. But the other thing that's in most subcontracts is the general contractor has the right to terminate you for no reason or any reason at all. That's called the termination for convenience clause. Now, you as the sub don't have that same right, but they can.
Interesting.
So that's another. And so even if they wrongfully terminate you because they didn't give you a chance to cure your default, they can just say, I terminated you for convenience. Another place that is used is if they find somebody else cheaper to do the work before you get started, they'll just terminate you for convenience, even if you already have startup costs, mobilization costs.
Yeah.
You're toast. You don't get any of that back. So,
And so people are just signing these. They're just like, oh yeah, it looks good.
Oh, and here's the other thing too. I kind of skipped over this, but your bid is a legal offer that can be accepted. And I actually had a client come in the other day that had bid something late in 19, was glasswork. Didn't actually, because it was paused, didn't actually get started until sometime in 20. And his scope of work had increased so much he didn't sign the subcontract, right? He didn't want to do it. They found another subcontractor to do his scope for $150,000 more. But he didn't put any limitations on his bid, like if cost of material go up or this bid expires in 30 days. And he actually signed a piece of paper that said, I understand that the GC is relying on this bid and it's true and accurate. And so now they're suing him for that $150,000 difference.
What?
He didn't even sign the subcontract.
Oh my goodness.
It starts all the way back at the bid. And then, the other thing is that whatever you bid is not what you're hired to do in a subcontract. The scope is what you're hired to do. And the bid does not become any part of the agreement between you. So make sure that the scope attached to the subcontract is what you put in your bid or what you agreed to do. Don't just assume that the two are the same, because 90% of the cases, they've changed just a little bit between the time that you did the bid and the actual plans for the project that are now the scope. Wow. And so that's another one that people take for granted.
So what's something what I'd love to do is, I love this storytelling that you can do where it's like the tale of two. And so I would love to go through this process of like, let's tell the tale of two subcontractors, one that decides to start out with a good lawyer and good contracts, employee handbooks, all the different legal documents, good bids, scope of work, all that kind of stuff, and someone who's reviewing contracts for them. And then the subcontractor that doesn't, what are the issues that they really run into? So, let's start with the one that doesn't use any of this stuff, who doesn't take legal serious, who is the handshake guy. What are some of the issues that you most commonly see? We've gone through some of these clauses that they run into, but what are some of the things that you typically see when they eventually come to you?
Well, the handshakes are always the worst deal. And here's the thing. They think that the smaller the project, it doesn't need a contract, right? Those are the ones that actually need a contract. And here's why, right? Especially if you're the contractor and you're working with like a homeowner or something, and who has no idea how construction works. Yep. They have an expectation in their mind of what you're going to do, how fast it's going to go, all of these things. And you have an expectation that I promise you is completely different than theirs. And what that contract does is it says, no, here's the group expectation. And it really gives the owner something, okay, here's what I can expect. My misconceptions, because I knew nothing about the industry, have now been corrected. And here's where I can go, and I know what's going to happen. Right? It's got the schedule, it's got all the things in there. And if you don't, what happens is very fastly they get pissed off. I cannot tell you how many pissed off homeowners that I talk to, and they either don't have a contract, the contractor doesn't answer their phone calls, and the main thing is just communication, right? And if you don't communicate, we're talking bad reviews, lawsuits, all the things. And here's the thing is, if you get sued and you don't have a contract, you might as well just pay them whatever they're asking, because it's going to be cheaper. It's going to be
Yeah,
cheaper than
litigation's
paying
not
me.
cheap.
Yeah, exactly. Then paying me to try to figure out to prove to somebody what the agreement was if it's not in writing.
I'd love to.
We did an episode last week, which we call onboarding customers, and positioning document, expectation documents. Maybe there's an issue with this, but the way I used to do it, and a lot of my clients do it, is you have your contract over here. And what I tell people is, me included, a lot of times people think a contract doesn't say what it says because it all refers to the first party and the second party and the back and the forth, subject to paragraph. So okay, I understand lawyers could dig into that. We have another document that just outlines expectations, and it's not the contract, but it just says delays. A 1-day rain delay doesn't mean that we start the next day because we went to another job. You have to make selections by this time. You see any danger in that?
There's no danger in that, but they shouldn't have to be two different things, right? Like my contract especially in that situation, is written in plain English. So it's got you covered legally, but at the same time, it's got all those things incorporated, because those things are just as important, right? I don't see any problem with doing it as an exhibit, but there's no reason that a contract you're going to sign to be bound by, you shouldn't understand what's in it. There's nothing that I have to say in a way that you can't understand it to protect you legally. It's just, the two things are not mutually exclusive, right? You can have both.
So do you think,
and a good lawyer can do that for you?
That's really a good point, because that's not the way most of them are, as you know.
I know.
Yeah.
It's not at all. Do you think that people are making, like, is it the attorney that's making the language that way, or do you feel like it's the contractor that wants the language to be that way? It's more on the attorney side?
I think it's more on the attorney side. That's the way we were taught. And most of it is appearance, right? Right. You're gonna pay me some absorbent amount of money to write this contract. You want it to be, you want to think that it's bulletproof. And I'm here to tell you, I can make it bulletproof, and you can understand it. And I only, I think the legal system has done bad in the way they train people to think that the legal profession has got to be the man behind the curtain, right? Like the Wizard of Oz. Like, It's got to be something you don't understand. It doesn't have to be. I'm here as a counselor to help you run a better business, to let you know what the pitfalls are. But if I can't explain that to you in a way that you can understand, I'm not doing my job, right? So much of my job is a counselor, not as a lawyer, right? I want to help you figure this out. And don't get me wrong, it takes some time to go through this stuff and make sure, I have, like I said, I have a flat fee contract, $1,500. I ran it through my marketing department so they can understand it, because they're not lawyers, right? And if they can understand it, I know everybody can. I mean, so.
I'm just wondering, when you give a small contractor these changes to make or things to be aware of, and he or she has to go talk to the general contractor, who we're going to presume is more sophisticated. That's not always true, but we're going to presume that. How they do it, how they fare when they do that, what kind of pushback the general say, hey, you want to work, sign a damn contract. Or are they malleable? Will they change?
It all depends, right? I've seen some contractors say, no, it is what it is, sign it. And I've seen other contractors work with you, right? It all depends. I think a reasonable contractor, if you come with them with options, it's not just, no, I'm not going to sign this. Here are some other options that are middle ground. I think you have a way better chance at getting it done. But if they say no, then you got to evaluate your risk. Is it worth it to you to take this risk, or let somebody else take the risk? And knowing that if it goes wrong and falls down, depending on the size of the contract, it could be a huge impact. And like I said, there's tons of projects that go off and don't have any problems, but it's what happens when one goes wrong, because an attorney gets this contract and it's just a heyday, right? You might as well just whatever, just give them whatever they want, because if you haven't modified the contract to protect yourself, it doesn't really matter what you say or what you do.
We're talking about this kind of tale of two in some ways. That contractor that just goes ahead and, handshakes with the customer, doesn't really set the expectations. What are they actually going to pay in litigation fees? I know you said you might as well just pay the customer whatever they want. What's like a realistic expectation with litigation fees? What does that look like? I know there's an hourly fee. How many hours is going into this? What's the potential?
Well, I mean, to go to trial, even on a small case is like $50,000.
Okay.
The discovery process, getting ready for trial. And it's even worse when you don't have a contract, because I have to spend so much time finding evidence to prove what the agreement was, right?
Mm-hmm.
I got to do depositions. I got to go through all the emails. I got to go through all the texts, and I got to I got to somehow prove the agreement that you had without having it written in one place. And that is so expensive, right? And even if I could, the person's going to say, oh no, they said this, or they said this, just contradiction. And where in the contract, it clearly says anything you said doesn't matter. It's only what's in writing matters. So it's just an endless ball of litigation and time and stress. And, it's usually not worth it, just because now if you got sued, you need to defend yourself and figure out the cheapest way out. But if you're trying to move forward like you weren't paid, and they're saying you did bad work, and they're saying you didn't do what you're supposed to do, and you don't have a contract out, I won't take it to litigation for you, because I mean, you're gonna run out of money before we get anywhere, and then you're gonna hate me, and it's just not worth it at the end of the day.
Now let's keep with this tale of two. This guy that's not use the attorney. Let's say that they went to LegalZoom and got their contract, and they're using that to go into this instance with the customer. What's the difference between having that document or not having the document? Does that help at all, or is it worse? Is it?
It's definitely better to have something. Having something written at all that we sign is better than nothing at all.
Okay.
It's not. The problem with LegalZoom is that it's not particularly for your business and for what you do. So like, you're a roofer, and one of the biggest problems you have is that homeowners don't understand when they pull the shingles back, you didn't know that all that sheathing under there is bad, right? And it's going to cost extra. So most of those contracts aren't going to be set up to let the customer know that, hey, this could be an issue and it could cost extra. And so maybe you can't get that extra cost because you don't have it in your contract. So it's still dangerous. It's less dangerous than not having one. So there, it's a scale, it's a gray scale, right? From white to black. And you're, just above the white with something like that, which is better than having nothing.
Yeah. Interesting. Okay. So do something.
Yes.
But not preferably do something even more custom. But
exactly. And that's really why, having grown up in the trades and knowing the mom and pop shops that are actually out there doing the work, I've really come up with an affordable plan based on them. And I'm not trying to do a sales pitch. I really want to help people. And so I've created these things. And so for a contract, small residential, $1,500, call me, we do an interview. It's specifically for your business. You get it in 5 days. I mean, why wouldn't you? And you can use it on all your projects. I mean, it's so worth the investment.
It is. And I think what people fail to realize a lot of the time is they think that it's going to be so expensive. Like, that's the stigma, is like, I can't talk to an attorney. I don't have money for that. I'm barely making by right now. Or, I've got cash flow issues happening. But there's two things. One, the amount of stress that you're going to feel if you don't have these things in place is absurd, and it shouldn't be there. It's such an easy thing to get rid of, and to not have that stress and to have that peace of mind knowing that you're protected is worth a lot. But two, it's so much more expensive to do it later. Like, putting it off is the more expensive thing. Like, if you're worried about the finances, then do it now, because you're going to be paying a lot more later on if you don't invest now, right? So
anybody that's been in the business for any length of time can tell you the war stories, right? And so please listen to them. And here's the other thing. I think attorneys have a stigma, right? Like, the man behind the curtain, and we're too expensive, and we're just people too, right?
Yeah.
We're just people too. And I'm really good at what I do, but you guys are really good at what you do, right? It's just a difference. We're here to help each other, and I can help you. And if, I know that, the trades is a great way to make a living. It's an honorable place to be. And it shouldn't, it should be protected. And that comes with contracts. And
story about a contractor who bid a job, did the job. The general came back and said, you didn't finish it. They said, well, yeah, we did. They did everything that was shown there, but what they didn't do was they were responsible for the work that was drawn or could be reasonably inferred from what was drawn.
That's so stupid.
And anyway, the bottom line was they went and did the work. And reasonably inferred means, well, that's a toilet, so you got to have pipes. Well, the pipes got to go somewhere, so the pipes got to go through the wall and down and connect the sewer. No, I just was doing the building. No. And that's, yeah. If
That's
you can't
a relatively new term
right,
that's relatively new term that I've been seeing. And it's usually in the first 2 pages, reasonably inferred. What that is an open checkbook for the general contractor. If they missed it somewhere else, I, the GC, reasonably inferred. I mean, what the hell does that even mean? If we have a written contract with the scope, nothing needs to be reasonably inferred. That just aggravates me. Why would you?
Khalil was talking about stories, and there's one where you didn't do it right. We have another story. Monty Markham, who was one of our guests here, he's about a $13 million landscaping contractor. And one of the things that he says, which is stay in your lane. If you're this big, do that stuff, and maybe you can creep out of it, but don't jump up there and get that $30 million bill with the gangsters from New Jersey. Sorry, because they're going to eat you up. Well, Monty is pretty sophisticated, and they got him for $22,000 on a 7-figure project. But he's as tough as anybody from New Jersey. But if you're out there and that's your first time and you're awestruck and wow, I got this huge job, and they're going to eat you up. And Absolutely. So it kind of, if you can't afford, well, we have an episode, I think we do. It's called Mentors, Advisors and Mentors Checklist. And among them are bankers, CPAs, insurance guys, and attorneys, and safety experts. But get an attorney. Don't think you can't afford it. We're hearing real reasonable options here right now, and get started that way before you just get taken to the cleaners and you start to understand those things. Yeah, you can't. Talking to our audience, if you're doing it otherwise, you're not doing it right, and it's going to get you.
Absolutely. I have what I call my legal landmine checklist that I kind of go through. And so the first thing is,
show notes?
Yeah. The first thing is, are you incorporated, right? Let's be incorporated. Whatever state, it doesn't, where you're incorporated or what type of entity is really more of a tax question than a legal question. So what type of entity works best for you is tax. But the thing is, you need to be incorporated because why? That protects you personally. So if there's a default with a contract or something like that, they'll look to the business assets only. If you're not incorporated, then it's just you and your house is up and your bank account's up and everything you own is up. You're personally guaranteeing all the work that you do. So first thing, incorporation. Second thing is, do we have employees or subcontractors? This is a very dangerous thing. And I know as smaller guys, especially starting out, you don't want to talk about this, but you need to get it set up right in the beginning. So I have some great articles on my blog articles at the Cromeens Law Firm to tell you the difference, because what you call them doesn't matter. It's what the law calls them. And so if they are truly working for you, they don't work for other people, they don't have their own company, they are an employee. They are not a contractor. And if they are an employee, you need to pay them correctly. And unless they're a high-level employee, they are entitled to overtime. Even if you pay them salary, they still get overtime. And I won't get into, well, maybe a little bit about what can happen if you do that wrong, right? If you do that wrong, it's not just that one. And here's how I usually see it. It's like somebody gets in an injury, they hire an attorney who's a personal injury attorney, and they start asking them questions about their job. And they find out that they work at a construction company who's not paying them overtime. Well, hey, I got this other side of my law firm does contingency fee for lack of overtime claims. And so then the small business owner gets sued by that guy for not paying overtime properly. And once you're in that federal lawsuit, what happens is the court lets the other side get your books and records for the last 3 years and send out letters to everybody who's worked for you and say, hey, did you get paid overtime? If not, you should really join this lawsuit. So very vastly comes from one employee to basically a class action of everybody that potentially worked for you for the previous 3 years. And so knowing and doing that right on the front end is so hugely important, because you can imagine how liability will stack if you don't. So that's the first thing, right? And then you have employee handbooks and safety plans up to date. So that's that, because one of the biggest places that these guys get burned besides contract is disputes with former employees. And if we don't have these things in place, it can get very expensive. So we need that. All right, so if you actually do have subcontractors, we need a good set of subcontracts that puts forward everything that they're responsible for. And if you're using the same ones over and over again, we have a master subcontract. You sign once and then just get a work order for each one. Again, clearly, plain, and it proves that somebody is actually a subcontractor and not an employee. And then if you sign other people's contracts, you need a system in place to have those reviewed and know your tools to be able to negotiate. If you are the one having someone sign your contract, you need a clear, easy to understand contract, right? And I'm trying to remember the rest of my list. Employees contract. And then the other thing is, how do you CYA? Just knowing how to cover your ass in a general business practice if something does happen, which means keeping all the records or having electronic system to keep all those records so that if you need them, that you have them. And so those are CYA, which is, like you don't have to think about it.
That's yellow in my
all
printer.
of those things are CYA, but specifically keeping documents, especially if a dispute arises. If a dispute arises, the first thing you want to do is timeline all of the events, even if it's just handwritten notes, because you don't realize how time distorts what things really happen. So if you have that on the date that it's written, and it's just so helpful, and a bunch of other things.
I've got a question for you, because documents are so important for you guys. I hate this. I hate working with contractors that are paper, because it is not how the world works now. Like, everything is on your phone, and that's the reality. And I think that makes it it increases the risk of you not having that piece of paper, So is that an issue that you run into, where things are on paper and then you can't find them? Do you like things in the cloud as an attorney?
I mean, I love things like as an attorney, and here's the thing, guys. If you give me 15 boxes and I got to go find something, I charge by the hour. I'll find it, but how much is it going to cost you? As opposed to everything online, I do a keyword search. There's all the documents that I need. Yeah. I mean, it just saves you time and money. And yes, there's always this one document that's a smoking gun, and if you don't have it, then it doesn't exist, right?
Yeah.
And plus, the other side is gonna put documents at me, like an email where they showed you where you were in default. I need the other side of that email that says, "Here's how I responded, and here's what happened." If not, it's just one side of the story. Yeah. And if you're not, go ahead.
That's actually one thing. Is this is really bad of me, but I'm thinking of the movie My Cousin Vinny, which is one of my favorite movies.
I love that movie.
He gets the box of like legal documents from the other attorney, like boxes, and he has to sort through them. Is that something that you put into contracts with like the GC or something, that, hey, when you do send over any legal documents, they need to be digital, not boxes of, other documents that you have to read through? Or no, is that not? Are you allowed to do that, I guess? You
can, but it doesn't matter, because when we get to the point of litigation, a lot of it is leverage, right? And a GC knows if they drop 20 boxes of shit on me, you guys can't afford it.
Is there anything you can do to avoid those boxes? Or like, can you say that it's just digital, like it has to be digital, rather than them sending over the 20 boxes of legal documents that you have to sit through?
I mean, you could try, right? And you could definitely put that in there. I don't know if a court would enforce it at the end of the day, because here's what they're going to do. They're going to come to the court and say, "Hey, I have all these documents. I'm ready to produce them. I know this contract says this, but it's unreasonable for me to have to scan this all in. I can just give it to them like this." So it's going to be, don't get me wrong. Like I said, part of litigation and the leverage is to make it hard on the other side. So even if they give you 2,000 electric documents that are PDF, I mean, that's still a lot to go through, even electronically.
Yeah.
And the only way to get to know a case well enough to take it to trial is to be familiar with everything, unfortunately.
Man, that's so hard. And that's why, I mean, as a small contractor or as a subcontractor that's not as big as the GC, that maybe has their own legal staff, and you've just got your hourly attorney that you're paying, I mean, you don't have the leverage, and so you have to protect yourself from the beginning.
Exactly.
So
That's why it's so important to stay out of those fights if we can.
yeah, you've got this checklist, and you've kind of walked through a lot of those things that are important for most subcontractors. Let's say they have that legal Zoom document that they're using as their contractor, the one they got from their friend in the industry that they tried to change the name of their company to this in the document, whatever. What's the most important thing for them to start with, if they're going to do things right?
I would start with a contract first for between you and your customers. Either start with having your contract written or having somebody review your contracts as they come in if you're a subcontractor. I'd start with there first. I'd start with the external things first and then slowly work through the internal things, which are employees, employee handbooks, safety plans, all those
Right.
things. But start with external.
Confidentiality agreements.
Yep. If one of those things takes you out, it doesn't really matter what you're doing internally. Absolutely the first priority, if you're not incorporated, go get incorporated. That's the absolutely first one.
Sure.
Sure.
Any business, but especially one in the construction
I'd like
industry.
to just touch on that just a little bit. That's a really serious problem. I've had so many clients over the years who just two people or maybe three people just got together, kind of threw together an idea. Let's start a business. Well, it's fair. We all get a third or we each get a half. And then 1 year, 2 year, 5 years, 10 years, something happens, divorce, death, you need more money. They're not, they don't all have the same amount of money. So the company needs money, who puts in what, and they tend to fall apart. Do you have some thoughts on that? I mean, is that something that you do also? The operating agreement, people might know them as. And what are some of the topics that you see they absolutely must consider in those?
Absolutely. I think that's so important because everybody just thinks they do it on a handshake or they do it on an email and they just get started and they don't realize how important having those things in place before you get started are, or even at the very beginning. Because as an attorney, if you walk into my office, you're ready to dissolve a partnership that doesn't have a written agreement, it's the wild, wild west. And basically you're going to end up paying a shit ton of money, both of you, to try to, if you can't come up with a dispute on your own. So, who owns what percentage? And even if you want to do a 50-50, that's fine. But having there a buyout procedure, right? Here's the thing about partnerships. They're hard. And even if you're best of friends, I have a rule. I run a law firm and I interview attorneys. And one of the things I tell them in the interview is I will never have a partner, ever. The only partnership that I have in my life is my marriage. And that is hard enough to work with. I can't imagine trying to, some people are successful at it and they can do it. That's great. But what will help you is a clear set of rules. Again, setting expectations. Here's what's going to happen if we don't get along. Here's what's going to happen if the company needs money. Who's responsible for what share? Here's what's going to happen if we decide to sell, buy out. Who gets to decide? Is there a silent partner? Is there a partner who's going to be doing all the work? What does that look like? Let's document that. I think
do you generally have suggestions for that? In other words, here's a buy-sell agreement that triggers on certain events. That's good that I know I have to do that, but well, gosh, I don't know. How do I do it? I mean,
we have a standard that, if you want to buy somebody out, you got to give them 60 days notice, and we got to go through an appraisal process and all this other thing, and then if we want to sell, it's all built in there in the front end, and we'll walk you through what it is. And if you don't like it, we can change it to whatever you want, right? But at least we have a standard set of rules of this. Here's how we can get out of this. Here's what happens if we sell it, and we can walk through it and modify it as we need to. Here's what happened if somebody's spouse died, if I died, does my share go to the spouse? Those are all things that, hopefully we won't have to deal with, but just in case we do. And, it's not $3,000 to $5,000 on the expensive end to get something like that done, because you're going to have a meeting, go through what everybody wants. So it's not affordable, especially if you're going into something as a startup. It's worth the initial investment.
I want to make the statement so people hear it, because in my experience, when you don't have that agreement, the underlying reason is you don't really value your business. You don't really see it. If you're just starting out with a pickup and you throw in with a buddy who's got a skid steer and you start working, oh yeah, you might talk about all these things. But if it's worth $35-50 million, you don't just shake. I mean, that's the fear and not thinking about it and how am I going to pay for it. Those are issues. But the fundamental thing is they really don't believe it has value. Not much. Once the value shows up, so do the problems.
Exactly. And if we don't have it planned out how it's going to go, it's a disaster.
Yeah. And it's so sad to see it
Well,
happen.
and here's the thing is that your work is personal, just as personal as your children and your home, and you care about it. And so when things are personal, pride gets involved, and it's really hard to settle disputes if you don't have something written.
And everybody has all the reasons the other person is wrong. And one of my points to people, and I'm not playing attorney, but I say, let's figure this out, because if that's your opinion, they're saying the same thing about you.
Exactly.
And it's also irrelevant. Doesn't matter. What's that agreement say? However poorly written, that's your forward. So
exactly. And basically what it is, it's the rules of engagement, right?
Yeah.
If we're going to get in a fight, here's the rules.
Do you ever see anybody come in who's already been in business with a poor agreement for a year, maybe two, and come in and say, okay, we need to make this a real deal?
Actually, what I had happen, I had a client come in and they had made a deal with a woman who was in the electrical business that they're going to be partners and they're going to start this business. And so my client was out there hustling, getting all these contracts signed and working and whatever. And so he's like, oh yeah, it's time to sign this agreement. She's like, what agreement? You guys are employees. If you want to buy the company from me, you can, which I helped him do because he had to. The verbal agreement was we're partners. What it actually looked like was they were employees, and that's how it was treated because they didn't have agreement to the contrary. And so they were kind of forced to buy the company at her asking price because they had all this work lined up. Her name was on basically, the people they were contracting with knew them, liked them. And if they didn't follow through on the contracts that were already signed, it was going to be on them. So they had to buy the company. Especially don't think that they won't burn you.
That in inequality, I don't want to say inequality, what do you call it? Mismatch. My dad used to say, if you marry an elephant, you're going to roll to its side of the bed. Mm-hmm. So if you're going into business with somebody who has attorneys, been around longer, has a lot of money, those kinds of things, and you don't, they very legally can, what people will always say, I got screwed. Well, you didn't get screwed. You agreed to it. You married that elephant.
You didn't agree to it, which is why you got screwed.
Yeah. And that's kind of goes back to what Monty Markin said. Stay in your lane. You can grow your way out of it, but stay in your lane.
And when you're going to grow, let's be intentional about it. Let's make a plan. What does this look like? Let's talk to people who are already at that level. What do they say? You know what I'm
saying? I had sold a company to some contractors in Las Vegas who bought a company that wasn't related, but they were big boys. They had a lot of money. But this might have happened to some of our listeners. I owe you $1 million. I want all my subs in my office Monday morning for a meeting. You probably know where I'm going with this. I owe you $1 million. Here's a check for $60,000. Yeah. You can take that and sign this document, or we'll see you in court. And half of them walk out with that check for $60,000, and some of them stay in there and say, no, we're going to make it. Anyway, there are guys who play like that.
No, absolutely.
And hopefully none of our listeners are dealing with them, but it's the other benefit of negotiating your contract, because if that is their intent this is titled Stop Getting Screwed, I think is the name of this podcast. Mm-hmm. If that's their intent, well, let's flesh it out right now for the cost of an attorney and go back and find some other work rather than fleshing it out when we owe them and we don't get paid.
If that's their intention, you signing their contracts is just giving them the bullets to shoot you with.
Yeah. Yeah.
Mm-hmm. Awesome. And here's the other thing is, even if you sign a bad contract, you could still have a lien. So knowing your lien rights, what's required for your state, you can still get paid. And if that guy, don't be wrong, even if you have a lien and it's been a while, you have way more leverage than somebody who doesn't. And that GC who was handing out the checks be like, hey, my claim's against the owner. I'm going against him. If you have a lien, right?
Right.
You got to do it right for your state. And then, a lien is a very powerful thing.
Yeah. What is the importance in the process of a lien? Like, how should liens be handled in your opinion as the sub? When should you be doing like the pre-lien? Maybe walk us through that process of how it should be handled correctly versus what it's probably being done right now by a lot of contractors.
Well, I think what's being done by a lot of contractors right now, they wait till they're starving and then try to figure out how to fix the problem. here's the thing is that there are lien laws in all 50 states, but they're all freaking different. And so I can tell you that they all require notices and they all require a lien to be filed at some time. And so here's my advice. Meet with an attorney that knows the laws in your states, or Subcontractor Institute's got them, or I can help you. And we set up a consistent collection process, whatever size company you are, that is the same no matter what. And it can be based on your cash flow, because even though a state might not require notice till 90 days after, you can send it early. You can send it more often. And especially you can use lien notices as a way around a pay when paid clause, right? Because if you send a lien notice, a notice that you might file a lien to the owner, they're going to get involved to make sure that you get paid. If that means, hey, the owner hasn't paid the GC, guess what's going to happen? The owner is actually going to pay the GC and everybody gets paid. So using lien notices as a tool to speed up payment. And so it's really based on your cash flow. Personally, if I was at 60 days, if I haven't been paid, I'm sending notices. That's just a good practice. And I think that fits into every state's rules. But specifically, you know what your state's rules are, and don't let anybody with a promise of payment push you outside what you need to do to have a valid lien in your state. Yeah. Because I see it happen all the time. You promised to pay, and I didn't file a lien, and now I'm screwed. Because with a lien, you have a claim against the owner. As where if you don't have a lien, if you're in a sub position, you only have a claim against the general contractor. And if the general contractor goes out of business or files bankruptcy, you're screwed. If you have a lien, you're still secured by the property. So it's so hugely important, and it gives great leverage.
Yeah, and you can set up processes to where, I think for some of the subs out there, they're thinking, man, I've got to call on every single job. I've got to call my attorney and pay him $2,000 to file the lien. You can do it yourself. You can set up systems and processes to do it right yourself. A lot of it make it a lot easier and a lot affordable, right?
Yeah, and actually, because this is such an issue, I offer a subscription pricing for liens starting at $1,000, $1,000 a month.
So I'm
your outsourced collection department. You don't get paid at 60 days. I'll make the phone calls. I'll send the letters. And here's the thing is that you can say, I'm the bad guy. Your attorney's calling me. I said, well, yeah, she'll probably pay me. She's kind of mean.
Yeah.
I'm scared to tell her not to.
And here's the thing. I don't have to be loud. I don't have to scream. I'm just going to say, hey, my client's owed money, and here's what's going to happen if he's not paid. And guess what? You get the system down. The squeaky wheel gets paid. You're going to get paid over the guy that doesn't have a process.
Right.
Yep.
It's just how it works.
There's some bad things that can happen if you file a lien incorrectly, right? Like
absolutely.
Let's talk about that a little bit. What happens if you do it yourself and you do it wrong?
I just had a client that had a $100,000 judgment against him for a lien that he filed incorrectly. And here's the thing is that he came to my office and he lied. And he lied about when he did the work. And so I filed the lien believing his lie. And it turned out when we got into this case, he lied about which meant his lien was late, which means he tied up this whole property for, 6 months. And the judge said, nope. Not only are you going to lose the $60,000 you're owed, you're going to have to pay them 100 G's. So the liability for doing it incorrectly is huge. And there are so many things that need to be done. Generally speaking, a lien is the security interest in a piece of property. And most liens on property, like a mortgage, you go to buy a house, you can't afford to pay cash for it, so you go to the bank and get a mortgage, and they take back a lien on the house, so you'll pay them back, and you sign off on that. It's a voluntary lien. You agree to it. A lien in this case, the mechanics and materialman's lien, is involuntary. The owner doesn't agree to it. In order to have such a strong remedy, you got to follow notices, do it timely. And if you don't, because it's such a strong remedy, the penalties for doing it incorrectly can be huge and painful.
Because you're interfering with somebody else's rights.
Yeah, because once you have a lien on that property, they can't get a mortgage. They can't sell it without taking care of that lien. So you're basically, incapacitating their things that they can do with their property. And so you have to make sure you do it correctly. And if you don't, it's huge penalties.
Yeah, we had a guest on one time who referred to liens as the superpower. And given everything that has gone so far, all the terms in the contracts and all the things it is something counterbalancing the little guy's rights.
I agree.
And big guy's rights too, if you're big.
Yep. And the thing is, just do it correctly. And it is a superpower because And like, there's no other businesses that have that right, right?
Yeah.
So, hey, there's mechanics men's, material men, and who has the right to do liens?
Anybody who improves a property with their labor or material, right? So you got to improve, and the outline of the rules are a little bit different in every state, but every state has incorporated landscapers, demolition guys, because like it used to be thought like demolition guys are removing stuff, so it's not really improving, but they've been added by statute generally. And you just know specifically for your state, and like there's small variables, right? Like sometimes delivery charges can be included in a lien, sometimes they can't. It just depends on the state, but the whole theory behind it is that you improve the property so you get to be secured. And
Yeah.
so as long as you're doing that, but you can't lien for, like, if your contract was for 20,000 and you only did $10,000 worth of work, you can only lien for that 10,000, the work that you actually
Mhm.
did.
Gotcha. Karalynn, one thing that we haven't talked about is your background and how you got started in this, because obviously you're super knowledgeable. You're on a mission to get into all 50 states doing all of this work. How did you get into supporting the subcontractor and being their attorney?
Well, it really started, I didn't realize at this time, but where I grew up. I grew up in rural Illinois with humble beginnings. My dad and his side of the family were farmers. My mom was a waitress. But then my grandfather on my mom's side was an excavation contractor, and my uncles were irrigation contractors. And so some of my first jobs were with the family business as, the irrigation contractor, and I didn't understand it at the time, but I saw the pain points, right? Making sure you
Yeah.
get paid, having to sign these contracts, and how it really affected the family, not only the business, but the family if stuff didn't go right. And then I went to law school, and in my last year of law school, my husband and I started a material supply company. And so I was really
Okay.
kind of thrown into learning, mechanics and materialmen's liens, because we had to protect our money as a material supplier. And then from there, it kind of grew, but it's always been home to me because it's where I came from. And especially the mom and pop shop, the people that I like to say get shit done. They're out there building things. They're really good at what they do. They need my help and support to make sure that's protected. And so I really take it personally. It's a mission, because like if my grandfather's excavation company ended up going out of business because he didn't get paid on a golf course, but if he had known the things that I know now, I could have saved that company. You know what I'm saying?
Yeah.
And for generations, it could have gone on.
Yeah. Absolutely. And it again, I mean, that goes back to it's a lot more than just getting a contract right. It's a lot more than making sure you get paid on the job. It's about keeping families fed and people employed and jobs running successfully, and really supporting the small guy at the end of the day, or your employees and your subs that you're using, your contractors. I mean, there's just so much that goes into it that's more than getting a contract done and having to pay for the contract. It's really about protecting what's valuable in your life.
Absolutely. Like you said, time away from your family to build this thing that deserves to be protected. And I've really set it up in a way that, because like when my husband was first getting started, phone call after phone call, what does this mean? What does this mean? And just to be there, that support, you need answers, and you need them now for a reasonable fee. So that's what I've created.
Yeah.
If we'll put your information in the show notes, and of course they can call you, but what should somebody look for in an attorney? Hopefully we've appealed to somebody driving around and convinced them, wow, I need to start somewhere. You don't just call attorneys are, different flavors and different specialties. You don't call personal injury to do liens, and you don't call maybe you do contract law, but not a family law attorney. How can they start the search, and how can they recognize that they've got a good attorney?
Someone that knows your lingo, right? Someone that understands your pain points, the things that, and it's hard. It's hard to find, especially in the construction industry, an attorney that has, because construction is its own job, is its own industry, and knowing anything about it, you've had to somewhere along the line, you really have had to spend some time in it, right, before you can really understand what to do. And usually, construction lawyers just do construction, because and that's all aspect, the liens, the contracts. But if you go to a regular contract attorney to draft your contract for construction, it's not going to work. there's just so many different variables that somebody who has those type of clients would understand. You've been in it and have those type of clients would understand, but interview them and talk to them about your problems and see if you'll be able to tell if they can use the same lingo, if they know what you're talking about. Not maybe specifically you're in your trade, but things like change orders and schedules and how important that is, because that's not usually things that are important in a general contract thing. But most of them have websites now that'll tell you, like, you can tell the flavor of a lawyer by going there. And really and honestly, just like stay in your lane, like the trades, an attorney needs to stay in their lane, right? I don't do divorces. I don't do wills. I stay in here what I'm good at, right? And you need to find someone that's in your state that, does that. I can help with a lot of basic things in all 50 states, but when it comes to litigation and things like that, but and having them as a partner, just don't call them when you're in trouble. Call them before. They can help you stay out of trouble.
It's 10:29 Central Time today. When should they start?
Yesterday.
By noon?
Yeah, exactly.
Seriously.
No, it's seriously. And
make an appointment. Right?
Exactly.
Or
like I have a free
search.
consultation. You want to go over legal landmines? Call me up.
Yeah.
We'll go through the checklist for free. That's the same in all 50 states. And then if I can't help you, I can at least point you in the direction to someone who can.
There you go.
But let's have the conversation of where are the holes, where are the pitfalls,
So if they take a long lunch, we'll give them till 2:00 to get started today.
Exactly. That's good.
Yeah, that's not kidding, man.
No, I know.
Pressure could be building somewhere right now, and you're not aware of it.
Exactly.
Well, it is building somewhere right now.
Yes, and here's the thing: is that there's nothing I can do that can stop someone from suing you. It's just what are your defenses and how fast can you get out of it? These things that you have set up will make that end faster as opposed to if you don't, and less expensive.
Yeah. Well, Karalynn, it's been a pleasure having you on the podcast. We will reference not only how to get in contact with you and some of the resources that you've mentioned, but we will reference your podcast, the Quit Getting Screwed podcast, in the show notes as well. So awesome. People should definitely check that out. And we will hopefully maybe have you on again sometime. It's been a pleasure talking to you, and really appreciate all the insight and the stories that you've shared. I know that it's been inspiring to me and helpful for me to understand some concepts, but I think it's also helpful for our audience. So, our mission is to not just help contractors quit getting screwed, but really to find less stress, more time, and more money. And I think exactly what you do helps them in that case. So appreciate all the knowledge you shared, and we'll be in touch.
Well, awesome. I have one other observation before we go.
Sir.
Oh, go ahead, Martin.
It appears to me that you like what you do.
Oh, I love it. I love
there
it.
There you go.
I love being the little guy and standing up to just jerks, right?
Yeah, that's cool.
That's great.
So,
all right.
It's fun.
Well, stay cool down there in Houston, Karalynn.
I will. You guys have a great day.
You too.
Thank you.
Thanks for listening to The Cashflow Contractor. Check out our website in the show notes or visit thecashflowcontractor.com.